subsection 2 of the Constitution provides for a particular mode for the determination of the motion of no confidence. In other words, whether that section requires the decision to be arrived at by secret ballot. I say this relates to all these issues because for exclusive jurisdiction, one requires a particular obligation which has not been fulfilled. In this case, the allegation being that this court, in terms of Section 167 4E, has exclusive jurisdiction to decide that Parliament has failed to fulfill a constitutional obligation. So, in order for a party to come to this court, a party has to identify the constitutional obligation that Parliament has failed to fulfill. And we submit that in order for the applicant to succeed in coming to this court under exclusive jurisdiction, it must show that Section 102, subsection 2 of the Constitution imposes an obligation on the National Assembly to have a motion of no confidence in the President to be decided by secret ballot. It's our main submission that the said section does not impose such an obligation. We submit that the section only confers a power on the National Assembly to pass a motion of no confidence in the President if the motion is supported by a majority of its members. And we say, when we submit, that the voting procedure for deliberating on such a motion is governed by the rules of the National Assembly. And the power of the National Assembly to make those rules is derived from Section 57 of the Constitution. Section 57(1) says the National Assembly may A, determine and control its internal arrangements, proceedings, and procedures, and B, make rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement. And then sub-rule 2 indicates or stipulates what the rules and orders of the National Assembly must provide for. Now, we submit that the National Assembly has actually taken a decision on whether or not notice of motion of no confidence in the President should or should not be done by secret ballot. Chief Justice asked the learned colleague, Mugai Toby, twice whether or not the National Assembly had taken such a decision. And regrettably, learned friend told the court that, there was no such decision. But if one has regard to the papers, firstly, paragraph 5 of the answering affidavit which states the following. It's affidavit of the Speaker. I also wish to bring to the attention of this court that when the rules were amended pursuant to the decision of this court in the Mazibuko matter referred to in paragraph 33, footnote 6 of the applicant's founding affidavit, a proposal was made to include a provision for a vote by circuit ballot, but the National Assembly declined to adopt the said proposal. Now, that allegation is admitted by the applicant in the replying affidavit, and this is to be found at paragraph, unfortunately my papers are not paginated, but I'll refer to the paragraph. At paragraph 40, subparagraph 4, subparagraph 1, I'm indebted. Learned colleague says that this is at page 327 of record. Where the following is said by the deponent to that affidavit, as the Speaker herself recognizes in her affidavit at paragraph 5, after the Mazibuko judgment, there was an attempt to amend the rules to provide expressly for a secret ballot for no confidence motions, but this was rejected by the National Assembly. Now, there's no application to have that particular decision reviewed and set aside. So we can accept that that is a decision of the National Assembly, which was called upon to deliberate on the very issue that the court is called upon, and decided in its wisdom not to include such a provision. Now, the Speaker of the National Assembly is subject, obviously, to the decisions of the National Assembly. She cannot, in our submission, override decisions of the National Assembly. If the National Assembly decides that it is not going to subject motions of no confidence to a secret ballot, we submit that she cannot unilaterally decide that she is going to override that decision of the National Assembly and order a circuit ballot. And this is also in the light of the fact, as has been clearly demonstrated in this court, that there was a decision of 3 judges in the Western Cape which effectively held that such a procedure is not required by the Constitution. Now, our submission further is that, and one has reference to what this court has said in the economic freedom fighters case, which in our submission is the most recent iteration of the principles governing this matter. I'm referring to paragraph 93 of the economic freedom fighters case, where the Chief Justice expressed himself in the following terms: it falls outside the parameters of judicial authority to prescribe to the National Assembly how to scrutinize executive action, what mechanisms to establish, and which mandate to give them for the purpose of holding the executive accountable and fulfilling its oversight role of the executive or organs of state in general. The mechanics of how to go about fulfilling these constitutional obligations is a discretionary matter best left to the National Assembly. Ours is a much broader and less intrusive role, and that is to determine whether what the National Assembly did does in substance and in reality amount to fulfillment of its constitutional obligations. That is the sum total of the constitutionally permissible judicial inquiry to be embarked upon. And these are some of the vital limits on judicial authority and the Constitution's design to leave certain matters to other branches of government.
Since the 10 minutes has expired, does giving meaning to Section 102.2, read with Sections 42.3, 86, and Schedule 3, also fall outside? I'm sure the answer is no.
No.
It doesn't fall outside the the role of the court.
No, not at all, not at all. In fact, this court is enjoined by the Constitution to actually interpret the Constitution, and it's the ultimate interpreter of the Constitution.
Now, does the purposive interpretation of these sections point to a prohibition, permission, or an obligation to hold the vote in relation to a motion of no confidence by secret ballot?
Our submission, Chief Justice, is that an interpretation of these sections, all of them, 102.2, 42.3, 55.2, all points in our submission to an interpretation which, in the first place, shouldn't trench upon the field of autonomy of the National Assembly. In other words, the Constitution itself, properly interpreted in our submission, leaves the determination of this question to the National Assembly. We submit that if, in fact, the Constitution required a vote of no confidence in the President to be taken by circuit ballot it's the easiest thing on earth to say so. As it said so in the case of the appointment of certain constitutional entities what's this?
You've listed them: judges, public protector, and so on.
Well, I wanted to refer to Schedule 3. That's what I've been trying to say.
Let me put my question to you
Yes.
this way, Mr. Moerane. Is it open to this court? Oh, no, let me even forget about that. What, in your submission, is the rationale behind a secret ballot, voting by secret ballot in relation to the election of the president? Why is it necessary? Why don't people just do it openly? Why has the Constitution made that provision?
Chief Justice, it's difficult to give a comprehensive answer to that. We do not know why the framers of the Constitution decided on that specific provision, but we can offer some suggestion.
Let's start earlier, Section 19.2. Why general elections, whether it's local government elections or national elections, held by secret ballot? Why don't people just get gathered somewhere, they raise their hands, or they show everybody, yes, I'm voting for? Why is it regulated in that manner? What has been identified as the reason? Because there's a lot of writing, judgments, and so on. Why has it been identified as a necessity to participate in general elections through a secret ballot?
Chief Justice is referring to Section 19 sub 3.
3, not sub 2.
Yes, it is sub 3. It is sub 3A. Every adult citizen has the right to vote in elections for any legislative body established in terms of the Constitution, and to do so in secret.
Why? Why is that so?
I suppose, Chief Justice, is to try and eliminate any influence, negative influence on the voter. In other words, not to go with your employer to the ballot box and carry out the instructions of your employer, or anybody having authority over you influencing your vote.
Or any institution.
I beg your pardon?
Or any institution, any entity.
Well, particularly vulnerable people, particularly those who might be easily influenced by the presence or undue influence of people in authority over them. And in this country, you can imagine millions and millions of people for whom that particular provision has been made.
Does it apply, or does it do those considerations apply, or do they not apply to Schedule 3, Part A, Item 6A?
Chief Justice, they may or they may not, particularly because there you are not now dealing with economic power relations, which in our submission plays a very vital part when you are dealing with general elections. There, for one thing, that is the first Parliament, let me put it this way, and every subsequent Parliament or every subsequent presidential election. But then you are dealing with a person who has no track record as far as that person's performance in Parliament or the National Assembly or in government is concerned. And you are dealing with a new National Assembly of new members.
Well, no, not just new. It may even be your second term, but why the secrecy? You may even be voted into office for the second time after the first 5-year period. But why the secrecy?
Well, Chief Justice, it could be for a variety of reasons. Some of them which have been articulated by my colleagues, and others which we might think up as time goes on.
I wanted to hear from you. I wanted to hear to have the benefit of your own viewpoint in relation to why you believe it was considered necessary to make that provision in relation to electing the President, the Speaker, the Deputy Speaker, and even at a provincial level into office, but it is not permissible, it is not even required to hold the vote, to conduct the vote for the motion of no confidence by secret ballot. Why the differentiation, apart from the mere fact that it's not there, it's been excluded?
Chief Justice, with respect, it is not our case, as has been articulated by some of our colleagues, that it is not permissible. That's not our case.
Is it permissible?
Yes, it is permissible if the National Assembly decides to do it that way. But it is the National Assembly that has to decide on that. That is our stance.
No. Is it capable of an interpretation by a court of law that says it is permissible? In other words, may we interpret that section in that fashion?
With the greatest respect, Chief Justice, I do not think an interpretation which says it is permissible takes the matter any further. That is not the issue. The issue really before this court is it obligatory, not whether it's permissible. A million things are permissible that are not unlawful.
No. Let's take it in stages. Do you contest an interpretation that says the National Assembly or the Speaker is permitted to authorize voting by secret ballot? Do you accept it, or do you want to debate it?
What I accept, Chief Justice, is that the National Assembly is permitted to hold a no confidence vote by secret ballot. But that does not really answer the essential question. The essential question is the National Assembly obliged? Is there an obligation? Because as I've indicated, there are lots of things which are permitted. But that is not the question. The question is there an obligation? Firstly, for the parties to have direct, for this court to have exclusive jurisdiction. And secondly, for the National Assembly itself to know whether it is under an obligation to do this or whether it is merely permitted to do this. Our submission is that there is no such obligation flowing from the Constitution. That's our main submission.
Mr. Merare,
Yeah.
you have just submitted that the National Assembly is permitted to hold a vote of no confidence by a secret ballot.
If it so decides, that's the question. If it so decides to do that, but I beg your pardon, it has to be the decision of the National Assembly, not any other person. That is our submission.
Where does that come from? What is the source of that power that says dealing with motions of no confidence in the President by the National Assembly by secret ballot depends on what the National Assembly has decided?
With respect to Justice Jafta, the power to decide whether or not to have a secret ballot in motions of no confidence in the President arises from Section 57 of the Constitution, which allows the National Assembly to have its own rules, to make its own rules, and a rule which says or provides for a national for a vote of no confidence to be done by a secret ballot would then be a rule of the National Assembly.
Shouldn't that power in Section 57 be read also together with Section 102?
Yes.
Which serves a particular purpose?
Yes.
And shouldn't also that provision be read in the context of Section 42, sub 3?
Yes.
Now,
Certainly.
should then the National Assembly, in making rules, is it not obliged to make rules which will make it conducive for the purpose of Section 102 to be achieved?
Yes. Certainly.
Isn't the voting by secret ballot in the whole circumstances the only mechanism which would guarantee the attainment of the objective of Section 102?
With respect, no. With respect,
Not.
we submit that even an open vote would guarantee that.
But I thought it was agreed by counsel who argued before you that there's a potential risk if it is an open vote of repercussions towards those who vote in a manner that is not expected by their parties. So in order to avoid that, you would rather have a vote by secret ballot to eliminate the potential of risk which may impact negatively on the credibility of the process of voting.
Justice Jafta, we submit that such a view is premised on certain factors which the Speaker does not subscribe to. As we say in paragraph 10 of the Speaker's reply or answer, I won't read the first part. That this application is grounded on an assumption that the members of the National Assembly, particularly members of the African National Congress, are weak-kneed, timid, cowardly, unprincipled, and spineless persons, which assumption I'm not prepared to make. So she says she's not prepared to make that assumption that people, when they vote on a particular motion, no confidence, in open assembly, will vote different from when they vote by secret ballot. That is what she says. In other words, she regards every member of the National Assembly as an honorable person, as they call themselves, honorable so-and-so, who will vote in terms of their oath of office, in terms of Section 48 of the Constitution. That's the premise from which the Speaker moves.
You see, Mr. Moran, what concerns me, speaking for myself, what concerns me particularly is the decision taken by the National Assembly to say motions of no confidence will not be decided by a secret ballot. That, to me, creates a problem even in circumstances where there would be some risk to the process. The Speaker would not be free to allow a motion of no confidence to be dealt with by secret ballot because the National Assembly has decided that that will not happen.
Justice Jafta, as I've indicated at the beginning of my address, that is a decision that was taken by the National Assembly. It's a decision that stands. It's a decision which has not been challenged. It's not been reviewed. It's not been set aside. And the proper way of dealing with such a decision, if in fact it is found to be invalid, is to have it set aside, which would give an opportunity of the National Assembly to state why, in its wisdom, it decided to go that route.
Mr. Morani, if you finished with that question, I don't want to interrupt. I want to get back because I have some difficulty in understanding your basic position in this case. Do you accept or not accept that it is a legal question whether the Constitution prohibits, allows, or requires a secret ballot in a motion of no confidence?
That is correct.
And then I get to your second submission, and I may have misunderstood it. You say that legal question can only be decided by the National Assembly in terms of Section 57 and not by the courts.
No. That's not what I submitted. What I submitted, Justice Froneman, is a general submission that Section 57(1) of the Constitution gives the power to the National Assembly to decide how votes of no confidence are to be dealt with. That was my submission.
So, just to make it clear for myself, it doesn't give the National Assembly the power to decide whether the Constitution prohibits, allows, or requires a secret ballot in a vote of no confidence.
No, if there's a dispute about that, then it's obviously the court and ultimately this court that has to decide that issue.
Thank you. Then a last question from my side. You've referred to the National Assembly decisions not to allow a secret ballot. Do the rules prohibit a secret ballot?
The rules, in particular, Rule 102, which reads as follows. It says, unless the Constitution provides otherwise, voting takes place in accordance with Rules 103 or 104. Obviously, that is a reference to provisions of the Constitution which provide for a specific mode of voting, like Schedule 3, amongst others. And to a certain extent, I suppose Section 89, which prescribes a particular majority, and Section 102, which also, in a sense, also prescribes a particular majority. Then one obviously has to go then to 103, electronic voting system, which in Sub-Rule 6, 1036, says members' names and votes must be printed in the minutes of the proceedings. So there appears to be a peremptory provision at the end of that rule that in terms of 103, members' names and votes must be printed in the minutes of the proceedings. And 104, sub 3, that if the manual voting procedure permits, members' names and votes must be printed in the minutes of proceedings, which would seem also to preclude a secret ballot. Our learned friends have referred to 103 subsection 1, which states as follows: at a sitting of the House held in a chamber where an electronic voting system is in operation, unless the presiding officer directs otherwise, questions are decided by the utilization of such system in accordance with a procedure predetermined by the Speaker and directives as announced by the presiding officer. And 104 sub 1 says where no electronic voting system is in operation, a manual voting system may be used in accordance with a procedure predetermined by the Speaker and directives to be announced by the presiding officer. So those are the provisions which seem applicable to the question.
And what is the answer?
Well,
I'm not being facetious. If the answer is no, that the rules prohibit secret voting, then speaking for myself, in view of your acceptance that it's open, or at least not open, it's necessary for this court to make a determination whether the Constitution allows, prohibits, or requires. If this court comes to a conclusion that it either allows or requires a secret ballot, and the rules prohibit it, what then?
Well, Justice Froneman, obviously, if the rules unlawfully prohibit the holding of a secret ballot, then to that extent the rules are invalid.
What does that rule that you've just read to us mean, 103? Does it give the Speaker discretion?
It does give the Speaker a discretion where it talks about a procedure predetermined by the Speaker. But what I'm not certain of, Justice Cameron, is whether the procedure that the Speaker determines has to fly in the face of a decision of the National Assembly.
We are not told, so far as I know, and please correct me if I'm wrong, whether that decision on the secret ballot taken by the National Assembly was part of the process of formulating and promulgating these rules. Is it embodied in a motion of the National Assembly, or is it simply a decision that the National Assembly took when the opposition parties, as we've heard this afternoon, tried to get the secret ballot put into the rules? Or are you arguing that there's some separate decisional power to be given to the National Assembly decision, or do we simply look at the rules?
Justice Cameron, I'm not certain as to what the process was. All I know and what appears in the Speaker's affidavit is that this was done in the process of amending the rules.
Doesn't it follow, Mr. Morani, I apologize for interrupting you, doesn't it follow that we need to look at the rules? We don't look at whether the National Assembly expressed itself in a particular way in enacting these rules. We now have the job, which you've already conceded is ours, of interpreting both the Constitution and the rules. That was done in both Ambrosini and Mazibuka, and no one disputed it. So now we need your advice and your submission on behalf of the Speaker of whether Rule 104 particularly confers on her the power to specify a procedure which will include a secret ballot. If it doesn't, and if it does sound lawfully, you've already answered my colleague Froneman, but we need your submission on that question.
Justice Cameron, all I can say is that the procedure has to be determined by the Speaker, it is obviously a procedure which, to a large extent, I assume, has been in place. The exact mechanics of it, I'm afraid I'm not able to say, but it is a procedure which is in the province of the Speaker to determine.
Does that mean yes?
Justice Cameron, that's the best answer I can give under the circumstances.
And that means yes.
Yes, that's the best answer I can give under this.
Mr. Moerane, does the end of Rule 103, which deals with electronic voting system, and the end of Rule 104, which deals with manual voting procedure, both end with a provision in regard to Rule 103 that says when all members have cast their votes, the presiding officer must immediately, I should read 6, sub-rule 6. Members' names and votes must be printed in the minutes of proceedings. And when you go to 104, sub-rule 3, it says, if the manual voting procedure permits, members' names and votes must be printed in the minutes of proceedings. Let's talk about 103, sub-rule 6 first. What does sub-rule 6 mean? Does it mean a disclosure of the names of the members and how they voted, or what does it mean?
Justice Zondo, it appears from the wording that it means not only the names but the votes, because it says members' names and votes must be printed in the minutes of the proceedings. It would seem to suggest that the names of the members who voted yes should be printed in the minutes. The names of the members who voted no should be printed in the proceedings.
Well, if that is what it means, would it not follow that therefore, at least under 103, we'll talk about 104 just now, would it not mean that therefore, under 103, Rule 103, the phrase that says in sub-rule 1, unless the presiding officer directs otherwise, that directs otherwise would not mean that she could do anything that would be contrary to sub-rule 6. In other words, whatever it is that she can direct otherwise is not something that would go to the concealment of the names and the votes. Just assuming that you are right,
yes,
when you say sub-rule 6
yes,
seems to require a disclosure of how the members voted.
Yes, yes.
Well,
that is so, Justice Zondo, and procedure, I believe, possibly means whether it's a vote by show of hands or by a ballot, but not referring to the question of the secrecy. Yes.
And I'm sure Mr. Mpofu in reply will deal with that. And then with regard to Rule 104.3, I'm not sure that I understand what it means. Well, the second part of the sub-rule seems to also contemplate, it contemplates the printing of the members' names and votes in the minutes of proceedings. But it says if the manual voting procedure permits. What is that manual procedure permits, and what does it mean to say if it permits?
Firstly, Justice Zondo, the manual voting procedure is available only when no electronic voting system is in operation. Then, secondly, I presume that the manual voting system is referred to there as contrasting with the electronic voting system.
Yeah, I understand that. The part that I don't understand, and I would like you to help me, is, of course, I've never been an MP, so I don't have a full appreciation of their different procedures.
Neither have I.
When the sub-rule says, if the manual voting procedure permits, it seems to say to me, the names of members and their votes must be printed in the minutes of proceedings. Or rather, let me rephrase that. It seems to mean you will only print the names of members and their votes in the minutes of proceedings if the manual voting procedure permits. That's the part. When does it permit? When does it not permit?
Unfortunately, Justice Zondo, I cannot throw better light on that unless I take instructions on that matter.
Because if one could understand what the first part means, it may well be that it serves the same purpose as Sub-Rule 6 of Rule 103, but it's just that it's got this condition, whereas Sub-Rule 6 of Rule 103 doesn't have a condition.
Yes.
It simply says members' names and votes must be printed in the minutes of proceedings,
yes.
Full stop.
Yes.
But Sub-Rule 3 of 104
yes.
says if the manual voting procedure permits,
yes.
this may be done, which
yes.
suggests if there are circumstances where it doesn't permit, then they would not be printed, the names of members and votes.
Yes, that's what a literal interpretation of section means. But as I've indicated, Justice Zondo, I'm not able to throw any better light on that.
Of course, the significance of the question I'm asking revolves around whether revolves around the scope of the discretion that may be said to be provided for in Sub-Rule 1 of 103 to say if you take Sub-Rule 6 away, maybe there would be little debate that the procedure which the Speaker may direct
yes.
may include voting by secret ballot.
Yes.
But if Sub-Rule 6 means the disclosure of the names and votes after people have voted, that might qualify what is said in 1, I'm not sure.
Yes, Justice Zondo, on reflection, it appears to me that the procedure referred to there refers to something like the showing of hands or ballot papers, and it doesn't refer to a question of whether or not the voting should be by secret ballot.
A secret ballot, just connecting with 1043, is it not a manual procedure? Voting by secret ballot, is it not a manual procedure? I don't want to bring in whether I once pretended to be a speaker or not. I just want us to look at the rules.
It would appear to us, Chief Justice, that a manual voting system is a sort of system that could be used if a secret ballot were to be.
That could be anyway, yes.
Yes.
Now, if there is a manual voting procedure that does not require of you as a member of the National Assembly to reflect your name, isn't that the one that would not permit your name to be reflected because it's not there?
Yes.
The one that would not permit for the minutes to show how any member voted.
Yes.
So secret ballot seems to be permitted here by 1043.
It appears so, Chief Justice.
So secret ballot can be used in other circumstances as well, apart from electing people into office, according to this rule?
It appears, Chief Justice, that a secret ballot could be used in terms of Rule 104, particularly where the members of the National Assembly do not have to disclose their names. Obviously, in an electronic system, I assume that their names are reflected.
So does it look like the Speaker has the discretion in terms of this rule, or had and has a discretion in terms of this rule to have authorized what UDM was asking for? Is it a fair assertion to make?
It would appear so.
Mr. Murani, following up on that, if the rules then provide for a discretion to the Speaker, do you accept that she must then exercise that and that she is not bound by any decision otherwise by the National Assembly? She must act in accordance with the rules. And if the majority party takes a vote and says, no, you shouldn't, then being independent, she must act in terms of the rules. Do you accept that?
I accept that. Yes. If Justice
You may proceed. I know your time has long expired, Mr. Mwerane, but we are to blame.
Well,
Are those your submissions?
those are submissions. The rest of the submissions, Chief Justice, are in our heads, and I'm not going to repeat them.
Thank you very much, Mr. Mwerane.
Scott, please.
Yes, Mr. Semenya.
Chief Justice and Justices, I forgo the privilege of not being interrupted.
Thank you, Mr. Semenya.
Thank you, Chief Justice. Chief Justice, the applicant says to the court that the case we are mounting is that a secret ballot is precluded when you consider a 1022 motion. That is precisely not our case. Let me state our case. The rules providing for a 1022 motion can do one of three things. It can make an election that vote would be open. It can make an election that vote is secret. It can make an election that vote would be exercisable with the discretion of the Speaker. Because to hold that vote as secret would not be inconsistent with the Constitution. Because to hold that vote should be open would not be inconsistent with the Constitution. To confer discretion on the Speaker would not be inconsistent with the Constitution. So it is open for the National Assembly when it does its function under 57 to make an election of which one of the three it wants to adopt for the purposes of considering 1022 motions. That is what is it. The debate, as I understand it, seems to want to raise the controversy by reference to saying, but when you interpret 102 and when you interpret the schedule, you must do so in conjunction with understanding and appreciating the provisions of Section 43. Of course, that is correct. What is not correct in that logic with respect is to allow there in 43 to creep in the question of risk of whatever type.
Mr. Morani, are you referring to 40? I beg your pardon. I beg your pardon, Mr. Morani. Mr. Semenya, I'm sorry. It has been a long day indeed.
It has.
I'm sure you understand.
I appreciate it.
You are referring to Section 43, aren't you talking about 42.3?
Yes, that's what I was referring to, Justice Nkabinde. That is the caveat that seems to motion voted by way of an open ballot inimical to the Constitution and what it seeks to obtain there. That's what it means.
Mr. Semenya, I'm sorry to interrupt, but could you also consider 55.2, which says the National Assembly must provide for mechanisms to ensure that all executive organs of state in the national sphere of government
that they would be open to this harm or that harm. That cannot be a good and convincing logic.
I think they've done it. They've said the judgment by the court.
But it is when it is a judgment by the court.
I think it's better not to say more than what I have said.
Indeed, Chief Justice.
The disclosure of which judge wrote the judgment has not led to enactment of a provision making the influence to be an offense, as we know that influencing members of Parliament itself saw it fit to make it an offense, so as to protect members of Parliament against any influence, improper influence. So the risk is there. Parliament itself has recognized the existence of the risk to the extent of making it an offense.
If there is an improper interference, that's a different issue. There can be an improper interference in exercising an open vote. How do the two dovetail? If you are entitled in law to exercise an open vote in relation to a motion, it cannot follow that you are breaching one of the rules of the House, and therefore you may be open to prosecution. May I meet this difficulty this way? If there is a risk, this is what we submit must be the logical resolution of that risk. Members of Parliament must go to the Rules Committee, and they must say to the Rules Committee, here is a risk, and here's the evidence of it, and here are the indicators for it. We then want you to advocate for a rules amendment. That's how you cure that. You don't cure that by inviting a court to say you are not capable of holding the executive to account because there is a risk looming of a description we don't know. That's not how it works.
But as I understand them, they say, you, Mrs. Speaker, you have power in circumstances of this nature because of the risk existing to order voting by secret ballot. And the Speaker says, no, I don't have that power.
Justice Jafta, might I say this to the court with respect? If there is a valid target of that attack which the applicants are making, it would have been the National Assembly itself to say when you are doing your 57 obligations of providing for rules in relation to a 102.2 thing, you did not consider this risk factor and therefore your decision falls foul of the Constitution. You don't go to the Speaker, who is obliged in terms of the rules of that National Assembly to respect them. So the formulation of this attack in our respectful submission is misguided. It is not the conduct of the Speaker that is an issue. It is whether or not, in terms of 57, the National Assembly correctly understood its obligation in relation to motion 102.2. That is where the attack ought to have gone. And if it did, it would have gone there last year when the 9th edition of the rules was adopted. That you're already making 103, 104 in circumstances that undermine the ability of Parliament to hold the executive to account. That ought to have been the case, but that's not the case. And that's why we're making the submission that is wrong, with respect. There is another element of the debate, now that I have the benefit of coming one but last, that occupied the court, and it related to the question of Section 19.3, political right to vote, which by the pronouncement of the Constitution makes it by way of a secret ballot. And also in relation to item 6.1 of Schedule 3, Part A. May I hazard an explanation, Chief Justice, Justices? The question of adult suffrage is a very long, controversial, historical difficulty that even international instruments have taken cognizance of. That if we want to allocate to all adults, regardless of wealth, strength, position, or anything, we want to guarantee them a free and fair vote to elect their representatives in government. We must acknowledge what my learned colleague Moerani says are economic factors, but I want to say not economic factors, but factors of influence in those type of relationships. If the slave masters could know how the slaves are voting, if the chiefs can know how their people are voting, if employers know how their people are voting, if spouses know how the other spouses are voting, if parents know how their children are voting, the risk is obvious there. There will not be a free and fair exercise of that franchise. That is the 19.3 explanation for why the Constitution chooses it this way, and also why international instruments also choose it that way. Now must come to the voting of a president. There is a wrong premise in the interpretation of 86. 86 does not say the election of a president has to be by way of a secret vote. It doesn't. What does say that is item 6 of Schedule 3, 6A. That is what it says, but it has a very, very useful operative word there. It says, if more than one candidate is nominated, so that's the predicate. The predicate is there must be more than one nomination for that position. And then goes to say a vote must be taken at the meetings by secret ballot. Now we know it is only on condition of contestation. The logic can't be correct with respect to say, if it provides for it there, why does it not provide for it when there is a removal? The answer is plain with respect, because there's no contestation when you consider whether or not the president must be removed.
I'm not too sure it's so simple, Mr. Semenya.
Okay.
Let me explain the difficulty as I see it.
Okay.
In relation to electing either the president, the speaker, or the deputy speaker into office, once there is nomination in line with the stipulated procedure, and nobody wants to challenge the nominee, that ends the story.
Indeed.
They don't want to waste their time and effort. But a motion of no confidence presupposes, and even Section 89, it presupposes that there is a reluctance to go. It presupposes that somebody would have approached you. Remember, before you can stand to be elected, even if you are one or declared, two people must nominate and you must signify agreement. Now, logic tells me that for us to begin to be debating as members of the National Assembly, that you must be removed and why, and even vote, it is because there is no signification on your part that you want to go. Otherwise, if there was signification, there was a document you were signing, as is the case when you are elected, to say, no, I want to. I want that which people are considering to happen. In this instance, say, I want to go. There can't be any vote. People will just accept that, oh, this person is ready to go.
Well,
and there is an anticipation that there may be people who support you in these difficult times. In those difficult times, so to settle the issue, there's got to be some voting that happens.
well, Chief
So
Justice.
I don't think the declaration of a person as president, speaker, or deputy speaker because there is no opposition is a comparator we should look at.
Well, Chief Justice, happily the Constitution tells us the manner in which that happens. It's not saying you will remove by a majority of votes of the National Assembly a president who is unwilling to go. That's not what it says. What it says is if you have lost confidence in him, whether he likes to go or doesn't like to go is irrelevant with respect.
I don't understand. If a person is willing to go, will you even table anything?
Well, he may be willing to go, but says, exercise your power to get me go. The question of his subjective feeling on the matter does not get introduced with respect in the analysis and the interpretation of the section. What it says is it is two elements that are necessary to achieve that result. The one is you must have lost confidence in him, and secondly, you must enjoy a particular majority for that result to occur. Those are the only constitutional constraints that I read into the section. It does not have anything to do with a subjective mind with respect, Chief Justice.
Mr. Semenya, I'd like to put something to you because it's important from my perspective. The purpose of secrecy in relation to the Section 19.3 situation, the Section 86 situation, and possibly the one where there's a no confidence motion. The purpose served by the secrecy provision in 19.3 is to ensure that there's an authentic vote on the policies and on the parties that are going to Parliament for the next parliamentary term of 5 years or whatever. The purpose of the Section 86 vote is to determine where there's a contestation, to determine who is the best person who's going to lead the execution of this policy and legislation for the next 5 years or in the future. Now, when there's a no confidence vote, and I'm putting the argument to you, I'm not saying that it is a correct argument, but tell me why it isn't. The argument is now there's a different purpose. Not the same purpose as with the original Section 19.3 vote, not the same purpose as Section 86, because that looked into the future. The purpose is now to say there's now a contestation. You haven't been doing your job properly in view of the past 3 years. Now we're contesting that you are the right person for the post. And now we want a secret vote. What I'm asking you is, why in those circumstances is it different from the Section 86 position?
Because, Justice Froderman, we're making the point that there is something the question assumes which is not supported by evidence. And it is this, that to hold the executive to account cannot be realized through an open vote. I don't know where we would get that as a predicate for that logic to work itself to the end with respect. Why can't you hold an executive?
I'm sorry. To interrupt. Yes. The logic may be that when the vote is being taken on this aspect, and I think it was alluded to earlier by my colleague Justice Jafta, it is a different function from voting on legislation. It is a function of holding the executive and the president to account. And that might explain why it's necessary to have secrecy.
And I'm making in response, Justice Froderman, to say that for the applicant to succeed, this court must find that an open vote is incapable or inconsistent with holding the executive to account. Now, that's a far-reaching, with respect, a far-reaching conclusion to make. Why? Why can't you make somebody account by showing your hand up? Because the logic goes, there is a risk of reprisal. Now, I'm saying if there is a risk of reprisal, it is not for courts to remove it that way. It is for the members of the Parliament to collate the necessary argument, evidence, and information and go to the Rules Committee and say, we want to address this and we want a rule amendment. And if the National Assembly is so convinced, clearly it would amend the rule and it would make it for a secret ballot. It's not for the courts to do it.
Mr. Moerane says there was an attempt, it was unsuccessful.
I beg.
Mr. Moerane says there was such an attempt, it was unsuccessful.
Because decisions of the National Assembly are taken on deliberation, persuasion, convincing each other. If they did not do that, if they did not tell the other members tangible indicators of this risk in particular, then that's what it is. The decision is what was taken. It is not for us to then import an incontrovertible risk as a premise, and therefore say, because there is an incontrovertible risk present, the courts would find that the National Assembly failed to appreciate its obligations in 57 when it passed the rules in the manner that it did.
Mr. Smeya, wouldn't your argument be more plausible, operative a word more to indicate that I'm not saying it's not plausible now. But would it not be more plausible if ours was not a party list system where the members of parliament would know that even though I belong to a party, but first and foremost, I'm answerable to my constituency. Down the line, it will be my constituency that decides whether or not I am returned to this parliament and not the party itself. Because now, to just say there is no risk, or rather perhaps maybe mischaracterizing your argument, it does not necessarily mean or automatically mean that there is a risk. But point is, if you are a member of a party, you are answerable to your party. Is the risk not there that there may be repercussions? And doesn't the fact that ours is not a constituency-based system make some difference? Or does it not temper your argument?
Well, Justice Madlanga, with respect, no, it doesn't temper my argument. And the reason for it in my respectful submission must be this. There is a subliminal assumption in the question that voting through a whip in a particular way is necessarily inconsistent with voting with one's conscience. I don't see that connection necessarily. It may very well be that voting in conscience is in line with the party direction. What's wrong with that? And the risk is not there. The problem with this debate, I mean the arguments with respect, is the following. It tends to assume certain things which are not evident, and then makes the leap with respect that therefore Parliament will fail to execute its mandate in keeping the executive accountable. That's the difficulty I have. Even this risk is very nebulous. We don't know its magnitude. Maybe it is one that elected officials are able to deal with, and perhaps it does not even present them with anything, even conceptually.
Conceptually, I think we were looking at the Supreme Court of Appeal, the Supreme Court of Zimbabwe, and the Appeal Court of Botswana, and saying, to the extent that the Constitution permits us to look at the laws as expounded on by other courts, we are looking at what our colleagues elsewhere have said. And this is what they have said about, essentially the same thing. I'm sorry I interrupted my colleague. I just wanted to highlight that it's not an imagination of any of us. It's a reference to case authority elsewhere, the neighboring countries. They are saying there are risks, and they tabulate them. And they seem to accord with the risks that are believed to affect situations relating to general votes, for instance.
Chief Justice, I concede readily that you find countries like Italy where the risk is to life, Honduras where the risk is to life. I concede all of that. The submission I'm making is to cater for that risk. It still lies open for the national assemblies of those jurisdictions to say, because we have a sound appreciation of this risk, we, as Botswana did, says we will prescribe our vote through a secret ballot.
As they have provided in their rules.
As they are provided for in their rules. That is a complete answer with respect to whether or not we modulate the jurisdiction of this court to go and cater for a risk which is inarticulated, and to do it ourselves as the judiciary.
Semenya, can we turn it around for a moment? What is the risk to the executive through secret voting, or to the party system? The party can instruct its members to vote. If its members are loyal and obedient and conscientious members, they'll presumably do so. And is there any downside to a secret ballot?
No, there's no downside, Justice Cameron, because again, we're going to back. If you have no confidence in the man or woman who is sitting as president, you don't have it. There can't be any risk if you are exercising that vote with your conscience or whether you're exercising it through your party authority. It cannot just convey a conclusion that to hold them accountable is only competent through a secret vote.
I understand the latter part of your submission, Mrs. Minya, but I don't understand the earlier one, which is there is no risk. Why do you say there is no risk?
I'm not saying there's no risk. I'm saying if there is risk, Justice Madlanga.
I thought you said so.
Okay.
I thought you said so.
Sorry, maybe it was inelegant articulation on my part. I'm saying if there is a risk, there is a constitutional method by which that risk is addressed. You go to the Rules Committee and you put the evidence there, and then they amend the rule. Despite the evidence of that risk being palpable, being demonstrable, they decide notwithstanding to persist, then you can come to court and say, this is irrational. You are exercising public power, you are doing it in a irrational manner, and I'm inviting the court to strike it off. That's how it happens. It doesn't happen by assuming it is there without evidence and then saying, I clothe myself with the responsibility, as the other party has said, to do a substitution. I'm going to tell you now what to do. That's not how we go about it in a respectful submission. Justice Madlanga.
Objectively, is there a risk or is there no risk?
I don't know, Justice.
No.
But I mean it in a serious sense, Chief Justice.
No, I'm very serious too. I'm very serious indeed.
Sense. The question of risk may even include geopolitical sensitivities that are there. I think if we were in Sweden, they would say, no, there's no risk at all. We have been here for 300 odd years, 400 years or centuries doing this thing without any consequence. And our public officials are not this type of people who are weak-kneed or who are spineless. They are able to stand their ground and demonstrate it to those that they represent in the National House of Assembly. Why not?
So you don't know whether, objectively speaking, there is a risk?
One, I don't know, Chief Justice, but it's not even an answer that I want to proffer. I want to assume if there is a risk, there is a constitutional method by which that risk gets addressed.
Now, allow me to interrupt you. If there is a risk, and here comes Mr. Moerane, duly supported by Mr. Mbofu, they say, look, there was an attempt to address the risk. Unfortunately, it's an issue of majorities. The majority couldn't be secured. The result is we are not able to deal with the risk. That's why we are here, to say, people, please, there is a risk, do something.
No, Chief Justice, if there is a decision of majority that proves irrational, the courts have the power to interfere. Then they must come here and say, despite the demonstrable evidence of this risk, look what this majority is doing. It's acting irrationally. And therefore, we invite in the court to intervene. That is how I understand our Constitution to work. You don't assume it and therefore then invoke the powers that the executive cannot be held to account purely because there's a risk. It must be one that gets addressed.
I don't understand the assumption part.
The assumption is we don't know what risk we're talking about in the first place. At least I don't. I don't know why 400 odd members of the National Assembly are at risk to exercise an open vote in relation to a 1022 motion. I'm not able to answer that one. All I'm saying is, assuming there is one, the Constitution does provide a mechanism through 57 to say to the National Assembly, we must make rules that are rationally capable of resolving this risk.
But you concede that that rulemaking process operates under the whip system.
It does. But Justice Cameron, it doesn't mean a whip system is inconsistent with the dictates of the Constitution either.
But aren't we going round in a circle then, Mr. Semenya?
I did not follow, Justice Cameron.
Well, we are probing the question whether MPs are able under the present system to follow their conscience or to face the risk of reprisals and retaliation if they do. And you are referring them to a system to change under which you admit that the whip and the party discipline will inhibit the change in the rules, because the party system in all the parties, I'm not picking on the majority party, as some of the opposition parties have got their same issues about discipline and hierarchy. And you're referring them to that very system when the inquiry is how do we secure conscientious exercise of a profound constitutional duty without risk?
Justice Cameron, I'm not able to make an assumption again that a whip system necessarily directs an outcome that is inconsistent with its processes, and that a whip system properly implemented would produce outcomes that are different to those that would be there if the people are exercising their vote through a free conscience.
Can we accept realistically, and if it's improper for us or it's beyond judicial notice, then tell me. That's why I'm asking the question. Can we accept that the whip system protects incumbency, not just in the majority party, but in the opposition party and the smaller opposition parties as well? And if it protects incumbency, can we also infer that it doesn't do the job of necessarily promoting conscientious scrutiny of an executive which in part controls the whip system?
No, Justice Cameron, it protects incumbency constitutionally. It does protect it constitutionally. It would be a different thing if that protection it affords is inconsistent with the obligations of these members under the Constitution. It's a different thing.
I appreciate that, but Section 102.2 assumes anti-incumbency. It offers an opportunity to subvert the incumbency that the whip system, as you say, justly protects under the Constitution. Isn't that why 102.2 is so special?
I must, with respect, express my difference, Justice Cameron, to make the point that it goes a little too far to say an open vote is incapable of achieving the National Assembly to hold the executive accountable. And I cannot say any more.
I appreciate that, and I'm grateful for your assistance, Mr. Semenya. You've helped, certainly helped me. I'm only saying that the Constitution has a whole host of mechanisms that protect incumbents, ministers, chairs of committees, opposition leaders, extra perks, extra protections. But 102 is very different. It actually says that the incumbent is at risk, and that's why I put my questions to you. The question is, how do we ensure constitutional processes that allow the expression of what 102 envisages?
I'm able to offer no different an answer to the question beyond stating that the Constitution in its own design has elected to allocate rulemaking to that arm of government and to allocate rulemaking to that part of Parliament. And in the exercise of that power, the National Assembly has said this is the election we make in relation to that 102 a vote. And if that decision cannot be shown to be rational, and the submission has been made, That's the end of the debate.
You heard our debate with Mr. Moorani. Would you assist us with your answers to the questions on whether 104 particularly, the 104.3, permits the Speaker to direct a secret ballot?
I offer a different answer to those questions, Justice Cameron, and the answer is 103 and 104 does not address itself to whether the voting is electronic, I mean, it's secret or open. You can still achieve a manual voting in respect of an open vote. Why not?
I think the question was, does it leave open the possibility for a secret vote as well? Is there anything to suggest, particularly insofar as it says where the manual voting system permits?
No, it does not.
I haven't finished. To the extent that it says where the manual voting system permits, does it not suggest that whereas it possibly allows for public voting of sorts, it does not exclude the possibility of a secret vote? That is why it contemplates it being not possible to reflect the names of the people who have voted and how they voted.
I meant no disrespect.
I know, Mr. Semenya. I know you. We're not roommates.
Chief Justice, I really am not able to go beyond the language of the rule. It seems to me to be doing one of two things: making provision where electronic voting system happens, and under 104, making provision where it occurs manually. But all of this obtains behind the decision of the National Assembly having accepted one mode of expressing that vote. If it had expressed even two, that it can be by open ballot, or the Speaker would have a discretion to direct otherwise, I can still see the language of these two rules being what they are without change.
Let's look at 104.3. What is it about the language of that sub-rule that suggests that it can only be, or it only contemplates, voting that requires the disclosure of names and how you voted? What is it about it that suggests that secret vote is excluded, especially insofar as it says if the manual voting system permits? When would it not permit?
I think the word qualifies the minute as opposed to qualifying the ballot. How would you have voted in such a way that the system does not allow you your name and how you voted to be reflected in the minutes? Chief Justice, might I give this my last shot at it? (104.3) must be possible even in respect of an open vote. And the next answer we would offer is to say, all of this happens at the back of a decision the National Assembly has taken of what mode that voting would occur. I can take it any further or higher than that.
I like the even. And two, I'm also mindful of the fact that the rules doesn't tell you, not doesn't, it's a plural. The rules do not tell you that the National Assembly voted in some way. So you're simply confronted by a set of rules, you read them, and you must interpret them. And they postulate a possibility of your identity as a member of the National Assembly and the manner in which you vote being so evident that it can be captured in the minutes, but also the possibility of none of that being evident, with the result that the minutes cannot capture who voted how. And why can't we say that is when, or that would be when, voting took place by secret ballot?
Well, again, because this voting is presided over by the Speaker, it then opens a possibility which I cannot, with my thinking, reasoning, analysis, countenance, which is this: that in the face of the National Assembly taking a decision as it did in this instance, that the vote would be by open ballot, or a secret ballot is rejected, that a speaker can say, I have a discretion to allow a secret vote. In the face of an obligation that says the speaker is bound by the rules of the House, I can't conceive of a situation where she's able, in the wording of 104.3, to direct for a secret ballot. I'm unable to get there.
I was only saying, as lawyers, looking at 104.3, the language employed there, why would we say it excludes voting by secret ballot? Just looking at the language. Let's forget the speaker for a moment. Just reading that sub-rule. What is it about it that rules out voting by secret ballot?
The speaker helps us. The speaker helps us and say, we had occasion as the National Assembly in the exercise of our 57 powers to make rules specifically addressing a 102.2 motion. She says so as much. And she says, of all the options that were there is one which we rejected. And that's uncontroverted. And that in part says, to then read in the text of that rule that which was expressly rejected by the National Assembly, and your lordships are told in no uncertain terms that that was the position.
So if the speaker had not said anything, it would then be open to us to give it its ordinary meaning?
If we didn't know, but we do.
Well, but how do we interpret the statute and the rules, Mr. Semenya? Do we listen to some people who were there to tell us what happened and then interpret the rules? Or do we just look at a section of an act or a sub-rule and say, what does this mean? Do we need parliamentarians to come and say, come, honorable ones, what happened? And then having heard them, we then say, all right, now we understand. With that background, this is what it means. I don't think so. Our responsibility as lawyers is just to look at what is there before us, what do these words mean, and give it a meaning.
I will never resist a proposition as clear as that. Clearly, interpretation has nothing to do with what those who have framed it are saying. It has to do a lot of, and the judgments of this court are replete with interpretation. I'm not going to advance that argument.
clarify one aspect with you, Mr. Morelani. Oh, my goodness. Mr. Semenya, you must be a twin brother of Mr. Morelani. Mr. Semenya, I seem to have a liking for Mr. Morelani. The President's assertion for opposing the relief by the applicant, as he says, is most telling, is the fact that he has not acted unlawfully. And I've been wondering why the lawfulness of the President's conduct is relevant to the determination of the issue.
No, those assertions in the papers bear no relevance to the interrogation we're having, Justice Nkabinde.
Mr. Semenya, not Mr. Moerane this time.
And we concede the point that because UDM could not appeal the Tlowama matter, that direct access would be competent. But 167.4, it's definitely not there. The Speaker is not Parliament. And we don't need to embellish the point in my respectful submission. Those are our submissions.
The submission that somebody made a submission that the President should pay. I assume that you don't accept that.
No, that we don't accept. It goes without saying, Chief Justice.
Yes. Thank you. Thank you, Mr. Semenya. Mr. Mpofu.
Thank you very much, Chief Justice. I will do my best, given the lateness of the hour and some of the developments.
Make me a promise. How much time do you need? So that I can hold you to it.
Yes.
And also decide whether we want to stretch our legs or not.
Chief Justice, you gave me 30 minutes.
Yes.
I can give you back 10 minutes.
Thank you.
Thank you. The reason I'm so generous, Chief Justice, is because of the concessions that have been made. We must just take stock of where we are now. Honorable Chief Justice.
Prefer not to be addressed as honorable.
Oh, yes. Yes, especially since after today that has been made synonymous with spineless. As the court pleases, Ma'am. Chief Justice, let's go to page 2. Let's go back to the basics. Page 2 of the papers.
Is that the founding affidavit?
Notice of application.
Okay.
Yeah. Where we are now is that prayer 3.2, the only party that gave opposition to prayer 3.2 has now considered. Remember that prayer says, it is declared that the Constitution permits motions of no confidence in terms of Section 102 of the Constitution to be decided by secret ballot. Mr. Moerane was asked, the first Mr. Moerane.
The real Mr.
The
Moerane.
real Mr. Moerane was asked a very direct question. Do you now accept that Section 102 permits motions of no confidence? His answer, paraphrased, was yes. 4.1, the next prayer, where we asked that for this court to say, it is declared that the National Assembly rules permit motions of no confidence in terms of Section 102 of the Constitution to be decided by secret ballot. A similar question was put to Mr. Morane. After some debate, his answer was yes, based on 104.3, which has been debated with both parties. And with the greatest respect, Mr. Morane's answers were correct and were appropriate in the circumstances. So, I promise one thing, Chief Justice, that I'm not going to mention the word discretion. If I do, then I should be punished. Because it is now clear, both from a reading of the Constitution and a reading of the rules, that, and the exchange that the Chief Justice just had with Mr. Semenya, that the rules, at the very least, contemplate a secret ballot or a method where you are not able to match the name and the vote. So then the question really becomes, then why are we here? The reason why we are here is because despite the fact that the rules provide for such a discretion, and despite the fact that the Constitution provides for such a discretion, when the UDM asked for the discretion to be exercised, we were told it is absent. That's why we're here. That's the only reason we're here.
Mentioned discretions 3 times.
That's why I didn't put a price to the fine.
Would you?
Yes, I do. So I'm mentioning it only to bury it, Justice Chafter. In other words, the only thing I can address this court on now is only the issue of the primary relief, which is why I gave away my time. On that question, with the greatest respect, I would like to start by asking the question and using a question that the Chief Justice put to my learned colleague, Mr. Nguraitomi. I'm going to use, in the morning, I used what I called the mischief approach. So I won't repeat that. In other words, why is there a secret ballot in the first place? And I offered the answer that it can only be, the only answer can only be the protection of the voter. Whether you are talking about the national elections or the elections in Parliament. The only reason why you can have a secret ballot under 19.3 or under 102 or under 86 is the protection of the voter. So let's put that aside. I would like, with the permission of the court, to now approach that matter from the point of view of what I call the effectiveness approach, but also maybe even before the effectiveness approach, the absurdity approach. And what I mean by that is this, which is what the Chief Justice raised. If there is a need to protect the voter, i.e. the member, in a situation where you are installing a person as a president, then how much more when you are actually removing an incumbent? In other words, now you are effectively punishing somebody. And as the Chief Justice correctly said, that is a painful exercise. So a fortiori, it must follow that if that protection is called for in the one instance, it is even more required in the other instance. But to that, to illustrate that point, I want to add even something more. In the one instance, you are electing, very happy occasion, a person, one person. In this other situation, you are removing about 35 or 50 people. Then how much more protection, how can the protection be less in the situation?
It's in the 70s if you include the
deputies.
deputy.
Yes. Well, yes, we're in South Africa. We're talking about between 50 and 70 people. Because the section 102 says that the president must resign, and so must the cabinet ministers, and so must the deputy ministers. So you can imagine the risk of repercussion is multiplied 70 times now. What logic could there be that now that the risk is multiplied 70 times, the protection must be taken away? It can be.
Mr. Mpofu, I think we've debated the logic of that, but you have to deal with the logic of the points made by Mr. Untalto and Ms. Bawa and the other counsel who seek to incorporate in their arguments the absence.
Yes. Well, those arguments, with the greatest respect, can be disposed of very quickly. One of those arguments was that, why close the door? If you remember, Justice Cameron. But who's closing what door? There's no door that is being closed. Just as in the death sentence situation that Justice Cameron reminded me about in the morning, the door is not closed. If this country decides tomorrow that it wants the death penalty, it will amend the Constitution. Simple. There's no door that is closed. So that's the end of that argument. The other argument which says, well, you must, it's a discretion, but it's not a discretion. So you must leave room for some situation where everyone is nice to each other and there's no risk. Well, let me just remind you, Chief Justice and Justices, the conditions under which these provisions were made could never have been better. The drafters of the Constitution, and all of us for that matter, I dare say, knew that the president who was going to occupy the position was none other than the great Nelson Mandela. Despite those are the best conditions, I dare say, that we will ever face as far as this question is concerned. But in spite of all that, the drafters of the Constitution said the election of the president shall be by secret ballot. It did not matter that we had this wonderful foregone conclusion. Why did they do that? They did that exactly because they knew that one day, irrespective of those conditions, one day there may be a situation where the
confidence to be brought.
Well, on the purposive interpretation we are contending for, they did. Remember, Justice Cameron, that's why we said, if this court finds that there is an obligation for the vote to be secret, people must not blame this court. They must blame the Constitution. It's not this court that, all this court is doing is to interpret the Constitution. In other words, the Constitution, what this court will be declaring the Constitution to be saying now, is the same thing the Constitution said in 1996. It's simply that nobody has brought it here. Just as if nobody had brought the case of Makonyane here, we would still have the death penalty. And if someone brought Makonyane today, and this court said, the death penalty is against the right to life, it wouldn't be saying that is now in 2017. It would be saying that was the case then. It's simply that it had not been determined. So my short answer is the drafters of the Constitution, by omitting as the Botswana case makes it clear, that omission cannot be read to exclude. Now, Mr. Semenya gave a very instructive answer where he was asked, at least he was asked the question, the challenge question I had posed in the morning. We have all here been at pains to demonstrate the benefits of a secret ballot. Countless, I cannot even count them now. And then the question was asked, I think, by yourself, Justice Cameron, to Mr. Semenya. What is the downside for a secret ballot? The answer was, I quote, there is no downside. So then why are we here? If we have a method by which you can enhance democracy, by which you can authenticate the outcome, by which you can hold the executive more accountable, by which you can put teeth into the Section 102 remedies, and so on and so on and so on. And that remedy has actually no downside. Then, on what basis can anybody ask this court to say, despite all those benefits to our democracy, to our constitution, to the quality of our leadership, and so on, we are still not going to do it, because if, despite the fact that there's no downside, it's untenable with the greatest respect.
Mr. Semenya, to paraphrase his position, is saying, look, there is another arm of the state here called Parliament. It's empowered to determine how it's going to handle its own affairs, its own internal procedures. So please leave it alone to decide what's best for it. They are responsible people. They have reflected on this thing. They couldn't agree. If there is anything to challenge, let it be the decision they have taken, but respect them enough, show confidence enough in them to handle their own affairs, rather than have the judiciary almost act like it's dictating to them what to do and what not to do.
Well, the answer to that is very brief, Chief Justice. The answer is that exactly where we started this morning. And that is one of the reasons Tlowama, by the way, is wrong. This court, in interpreting the Constitution, will not be interfering in anybody's business. This court will simply be doing its job. And there's no other institution that I know of that can interpret the Constitution. So if this court says, Mr. Mpofu and the UDM, you are correct, the Constitution, the meaning of Section 102 is that a secret ballot is prescribed. Full stop. That's the end of it. That is the end of it. This court doesn't have to do a single thing after that. And the court will not have interfered, will not have done anything to anybody except to do its job. Otherwise, all parties to a contract, parties to a marriage, parties to whatever, can say, well, why must the court interfere? The court is here to interfere with respect when there are disputes. That's its job. What else can the court do? If you don't want the court to interfere in your life, you must do the right thing. if you, there's a rule, a law that says you must cross the robot when it's green, and when it's red, you must stop. So the only way, if you don't want the traffic police to interfere with you, you must cross when it's green and stop when it's red. That's it. Then your life will be easy. The minute you do something else, then you can't say you're interfering with my driving. The court's sole purpose for existence is to do what we're asking it to do. Because it's very simple. It started with 2 letters. Please allow a secret ballot. No, I'm not allowed to. Boom. That was the dispute. Once that happened, there's nothing more we could do. Save to go and say, no, yes, you have. No, I don't have the power. Yes, you have. No, I don't. So the only way was then to come here and say, we as the parties, ourselves and Mr. Morane's client, cannot resolve this thing. We are saying they have the power. We are even saying they are compelled. That has been put up by these 2 parties to a relief under 3.1. And my humble submission is that there isn't. The next little question that I wanted to address is a note that I made. Justice Madlanga is very correct. Far from being the impediment to a secret ballot, the multi-party system might well be the even more reason why it should be. And I say this for the following reason. If this was a Westminster system, it might well be that this protection would not be as essential. This protection is even the more essential now that Mr. Smenya and Mr. Morane say that the reason why the schedule gives the protection it does, or rather even section 19.3, is because, well, what if your employer is there and he sees what you're doing? Well, in this case, who is the employer? The employer is the president. The employer is the party. So exactly as the Chief Justice was putting it, the same considerations that militate for the protection to be available are present here. Because in a multi-party system, those employers, now imagine, Chief Justice, with respect, that you are a cabinet minister who also happens to be a member of parliament. And now,
you mean me?
and that person then has to go and vote and say, well, I'm spineful, whatever the opposite of spineless is. and therefore, I don't want the secret ballot. I'm going to vote that the president has lost my confidence, at least. That's what my conscience tells me. And lo and behold, the motion is moved and the president survives it. Need I say more? It is those situations where this protection is needed. It's no use, with the greatest respect, to come and tell us that some MPs are so bold that whether it's secret ballot or open, they will vote in the same way. Well, good luck to them. This protection was not meant for those people. They don't need it. This protection was meant for normal people.
What do you mean? Is boldness abnormal?
Well, the average person, maybe that's what I should say. Thank you. It was meant for the average person who is likely to consider, is this a decision over which I'm prepared to take away my children from the private school? Is this a decision over which I'm prepared to walk the street? If I'm uneducated, is this a decision over which I am prepared to go back to, if it was me, my village and bask in the sun? That notional cabinet minister, with the greatest respect, it was the target is the target of the protection we want this court, we submit this court should confirm. That is the reality of life. Not this, we're all hugging each other and therefore we must leave a gap for a situation where the protection might not be needed. Well, the last thing I can say is that if the 19.3 says that you must vote by secret, it doesn't matter if in that particular voting station it's made up of criminals of the West Order, and in the other voting station it's just priests.
Real priests.
Real priests. In both voting stations, the voting is by secret. It is not fact-based or situational. It is a protection that is afforded generally. And despite the fact that those priests might actually, coming out of that voting station, tell each other, I voted so-and-so, I voted so-and-so, it doesn't matter. They are still afforded the protection. It's up to them to waive it, because that protection is not for them. That protection is for the democracy. That protection is for the system. That protection is for the accountability, and so on and so on. It's not for individuals who might be good or bad or indifferent. And that is all we're asking for. All we're asking for is...
Are you still sticking to 20 minutes?
Well, under the usual rules, Chief Justice. Okay, so then let me move out and just mention, well, I won't say the last point. The other, we've all said about how toothless, negatory, and all that the vote would be. But remember that there are three things that the Speaker has to do: schedule, debate, and vote. Now, it would be the debate. I want to just focus on the debate. The debate, which is compulsory, would be fruitless if the party bosses actually are the ones who have decided. In fact, I go as far as to say the whole thing of having 400 MPs would just be a joke.
People must just submit their position.
Absolutely. We should have 12, we have 12 political parties. Then we should just have 12 MPs. It will save us a lot of money of this flying up and down. And then those 12 MPs will just have weighted votes. Weighted votes. If I'm the MP for the ANC, my vote is weighted to the extent of 62%, and so on and so on and so on. In fact, you don't even need MPs, you just send a fax, or that shows my age, or an email to say, well, on this motion of no confidence, we as the ANC, we say this, and this one says this. Otherwise, the whole thing would be not only fruitless, but it would be laughable, a sham of major proportions. Now the last
Finally.
one. Yeah, finally. Yeah. Well, let me just clear up one thing. It's been said that when this was debated in Parliament, that we have agreed that it would be rejected, that the secret ballot would be rejected, or words to that effect. Well, if you go to page 327, Mr. Morane, regrettably, as he put it, did not read our full reply. Our full reply is this. As the Speaker herself recognizes, I'm reading 40.4.1. As the Speaker herself recognizes in her affidavit at paragraph 5, after the Mazibuko judgment, there was an attempt to amend the rules to provide expressly for a secret ballot for no confidence motions, but this was rejected by the National Assembly. He stopped there. This is how the next sentence reads. The Speaker does not provide any explanation as to why a different outcome should be expected now. It may well be that it was felt that the rules as they stand already catered for that eventuality as contemplated by the UDM and others. That's exactly the issue. It's like this thing about you didn't exhaust internal remedies, you should have asked to amend the rules. Why would the UDM want to amend the rules which it claims cater for a secret ballot? That is the point. The UDM in that debate says that we were happy to have the issue left open because in our estimation, the rules as they stand provide for the secret ballot. The most important point, cost. My Leonard team and co-leader has asked that we should ask for costs of 3 counsel and that the president pay the cost personally for the reasons.
Why?
Well, because.
Now let's have the benefit quickly.
Yes.
Why?
On top of what we have submitted in our heads, Chief Justice, what we say is this. The Constitution, our Constitution...
The ANC issue, is that the point you make?
That's the issue. The issue is a serious one, Chief Justice, because the capacity in which the president is entitled to use taxpayers' money is the capacity in which he was cited. That is more aggravated by the fact that the political party that he happens to be the president of was cited in its own right. That political party has chosen other political parties which are not here, even sent a notice to abide. That political party said nothing. One of the possibilities is that that political party agrees with the relief. Unlikely, but we cannot discount the fact that it's either they say we agree or we are indifferent. And despite all that, the president...
I thought your position was that, that political party has issued particular instructions suggesting that it does not agree.
Suggesting?
That it does not agree. It has issued instructions that people must vote in a particular manner or else. I thought that was your own argument.
Yes. Well, it's not just my own argument, it's the argument of the president. The president actually comes to this court and says, I'm paraphrasing, the UDM claims that we are going to visit adverse inferences, adverse consequences upon dissenters. He says that is correct. That is the advantage of being a majority party, and makes the following startling proposition. It is not the members of the assembly that are accountable to the people. He says that in his affidavit. It's not the members of parliament, it's the political party. The exact opposite of what was said in Mazibuko. So we have a new oath of office now, where the members of parliament are actually accountable to their party, and it's only the party that's accountable to the. What is that?
Yeah. I think I've heard you. Whether we agree or not is something to reflect on.
It's a different matter, but that is the issue. Please allow me.
Threatening to take half of the time you took earlier.
I just have a feeling that. Oh yes. The issue about the threats, and I'm going to say this very quickly. The threats are not just threats of expulsion. They might be threats of, let's say, removal from a chair of a portfolio committee, demotion, and all sorts of things, including the example I gave about the notional, yes. So the fact that a threat might not materialize. In fact, if the crime is that you must not threaten me, then you threaten me, you say, I'm going to shoot you. I go and report that you've threatened me. Then that is complete. It can be a defense. You can't say, well, I don't own a gun. It doesn't matter. The point of the matter is that the threat itself, the risk, as it has been said, is sufficient to trigger the protection. As the court pleases. Thank you.
Thank you, Mr. Mbovu. You seem to have more energy now than at the beginning.
Well, if I can use it usefully if the Chief Justice will permit me.
But let me just take this time to thank Counsel. You've been very helpful. You have no idea how challenging it was to try and conceptualize the issues properly until we had the benefit of your submissions. We truly and genuinely indebted to you for the enlightenment, for the patience with us, and for allowing us to have that short break and go all the way until it's about what
10
now?
to 8.
So almost 10 to 8. We really appreciate that, and for the public as well, the way in which everybody conducted themselves. Otherwise, judgment is reserved.
Thank you very much, Chief Justice. It will be remiss of me not to, and I know that I speak for all my colleagues, to also appreciate the audience that the court gave us and the patience and allowing us those extra minutes. We're indebted to the court in a very, very deep sense. As the court pleases.
Thank you very much. As I said, judgment is reserved and the court adjourns.
All right, so it's